Hey there, I'm reviewing 15, 25, 26, and 32 now. So 15 is about Poppy Rose, the attorney, and Marigold Laurel, the client. Marigold wants Poppy to call her boyfriend, Marigold's boyfriend, as an alibi witness. Poppy doesn't know, but she reasonably suspects the boyfriend will be offering false evidence. So what are her options under the rules? It's really here up to Poppy to make this call. If she thinks the witness is going to be presenting false evidence, then she can decide whether the witness should go on or not. If she knows that the witness is presenting false evidence, she really shouldn't put him on the stand. But here, she's not entirely sure. And since it's not her client, but an alibi witness who's taking the stand, she gets to make that decision. Look at Rule 3.3A3 and comments 6 to 9. B is not true. Our client doesn't call the shots on all the witnesses. The only thing we need to do is honor our client's wish to testify on his or her own behalf. And the client doesn't get an option to put up a parade of liars just because that's what the client wants. Withdrawing from the case, C, is an extreme option. You might decide to do that in practice, but we're looking for something that is not as extreme and won't leave your client hanging, so I would not go for C. And D, you should call gives Poppy the option to call the witness and impeach the witness on the stand. What kind of circus are you running there? You don't want to call a witness and then impeach your own witness, and that's really silly to do on the stand. It doesn't help your case, and it doesn't seem like you're advocating for your client. So let's move on to 25, 26, and 32. 25 we've already done, and it was in another segment. But basically the issue here is that Jorge has a personal conflict. But it's not a conflict. Remember, personal conflicts are waivable by the client, and they're not always imputed to other members of the firm. So if you get a client to sign off on this, if you give your client all the facts and they're able to give informed consent, confirmed in writing, and they still want you as an attorney, and the other side knows about you representing the defendant, so the plaintiff is well aware of the situation too, and everybody signs off on it, then you can go ahead. So that's why B is the right answer. It doesn't disqualify Jorge's whole firm unless they all have some sort of personal relationship with Jorge's wife, and it's not a conflict that cannot be cured. So instead of all those negatives, this is a conflict that you can fix. Happens all the time because of our relationships that we have with other people in the profession, and people move on from it. Okay, so number 26. Clarissa Hung once represented the Washington Area Transportation Authority in negotiations involving an accident with Giselle Fahimian. One of WADA's buses allegedly ran over Giselle, crushing her legs, and then the negotiations stalled and Clarissa lost her job. So now Giselle has asked Clarissa to file suit on her behalf against WADA for the same accident. So now WADA is her former client. Clarissa would be the new client. Which statement applies? Remember, former client conflicts are curable. You can go and get your former client's permission to do this. It has to be confirmed in writing. Now, what's the likelihood of that? It's probably not going to be entirely likely. And here we have a situation where Clarissa was representing WADA in a negotiation. So I wouldn't have been exposed necessarily to the same degree of confidentiality that we'd see in litigation. So you need informed consent by WADA. It doesn't, and B is correct because, incorrect because you are allowed to sue former clients. That's too broad. And C is incorrect because the rules don't make a distinction between negotiations and litigation. I just said that you could have gotten less information in a negotiation than you would have gotten in litigation. It's something to consider. It may affect how WADA considers the situation too. But your best option is to take it to WADA and see what they will say. Okay, so Thus, we've got number 26. Number 32. Sweetwater Simpson is about to interview Bryce Jones, a non-party witness in a bitter neighborhood conflict over dog waste removal. And Sweetwater represents two of the neighbors in the conflict. Bryce is an employee, relative, or agent of Sweetwater's client. So he doesn't have this relationship with the plaintiff either. So if Bryce provides unfavorable testimony when Sweetwater talks to him, Sweetwater wants to ask him to refrain from speaking to the other side's attorney. You know, like, okay, we don't really want you saying that. Could you go on a vacation to Mexico? So what is the propriety of the request under the rules? You can't make this kind of request of a witness. That's number D. You can make this request. The exception is you can make this request of a relative, agent, or employee as long as the interests of the witness are not going to be adversely affected by refraining from giving this information. We want to promote access to evidence. We don't want to tie up people. And the only reason we even have those original exceptions is for privilege. So, and C is wrong because it doesn't matter what Bryce's interests are here. He doesn't fall into one of those categories in which we do protect people from speaking out. You know, you can sort of see those categories as an extension of the kinds of issues that come up in situations where